All right then. Hello everyone. This is LB290 Public International Law tutorial clip by CSP. So now we're going to be moving on to finals with regards to our midterm score. I have no comments. Right, we're going to be talking about the last year's final exam. So this year's final exam is going to be by two professors and there'll be three questions. Two by อาจารย์จ๋า which one of them is 30 points, another one is 10 points, and the other, I think the other 10 or 15 points will be by อาจารย์แบงค์ นะครับ อาจารย์ธนพัฒน์ sadly he wasn't there last year, so there is no past exam questions for อาจารย์แบงค์ but I'm gonna talk about it now before I start working on the questions, which is basically for Ajahn Bank's part. He's explained in class that the scope of the exam is going to be within the slides. So he mentioned in class very specifically that you do not need to read anything more than the slides, which as opposed to Ajahn Jha, right? Ajahn Jha wants us to do extra research, right? So that is for Ajahn Bank's part. Now we're going to be moving on to Ajahn Jha's part. So this is question 1. What are the criteria of self-defense by a state? Do you agree that with the development of high technological weapons, the futuristic war will be invoked by, quote, preemptive self-defense? Explain your stance. Right. So let's separate that, right? Because this is quite a long prompt of we have to do. First one is quite obvious. What are the criteria of self-defense by a state? Self-defense. Do you agree, this is a key term here, with the development of high technological weapons, futuristic wars will be invoked by preemptive self-defense? Explain your stance. Okay, so we'll tackle them one by one, all right? So let's first tackle the criteria of self-defense, right? So when we talk about self-defense, the topic is very simple. The topic is going to be use of force. And what is use of force? So this is where we're going to be first explaining, at least according to that, firstly, the historical development of the use of force. Like, what is use of force? What is the historical development? This is where the slides are very, very useful in answering these questions generally. So let's open up the slides a little bit and let's go on to the use of force. So how do you answer that? Now, of course, you're not allowed slides in the real thing, but this is a tutorial clip, right? So you understand that you basically have to explain this. Right? So it's basically from antiquity, means ancient times, to the 20th century, which is a shift to self-defense. So explain this very briefly. It's not really the main focus. In fact, I don't really know 100% if it's relevant to the case or not, but hey, it relates to self-defense. You know, it's the development of self-defense. So maybe that is the case, right? Now, after you've explained the historical development, we move on to finally explaining, self-defense in general. And this is where your knowledge of the UN Charter is very, very useful here. Because the UN Charter quite literally outlines what is prohibited and what is not prohibited. So I would like to direct everyone's attention to Article 2, subsection, I think it was 4, right? And this is where we're going to open up the UN Charter here, okay? So the UN Charter, and then you go to Article 2, subsection 4, quote, all members shall refrain in their international relations from the threat or use of force against territorial integrity, political independence of any state, or any other matters inconsistent with the purposes of the United Nations. What does this mean? Basically means no use of force, right? No use of force unilaterally. You can't just go and invade other countries. That's wrong, right? But then that's not really what the question is asking. The question is really asking about self-defense and what are its criteria. So we check the provision most relevant. In fact, it's the only provision relevant to self-defense, which is Article 51. Okay, so what is Article 51? Article 51 states that nothing in the present charter shall impair the inherent right of individual or collective self-defense if an armed attack against a member of the United Nations, blah, 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 blah. The key term here is self-defense is allowed, right? Self-defense is allowed, whether unilaterally or collectively, right? So that is the case. Explain this. I do think that this is very, very important. If you don't explain this, it's going to be a big issue. What does it really mean, right? What does it really mean? Okay. Now, when you explain all of that sections, right? You need to now explain, okay, well then self-defense is allowed, but how is self-defense allowed? So this is where you need to go and finally answer the question of what are the criteria of self-defense? Right. Sorry, I type American English, but it doesn't really matter. Okay. So what are the criteria of self-defense? Now, as we learned in the class, and actually as our very useful slides have pointed out, one very, very key incident back in the 19th century really gives us some cases of what constitutes as self-defense. Right. So that is obviously the Caroline case, right? The Caroline incident in 1837. A little bit of a background to remind people of what it is. Basically, it is a case of a ship called the Caroline, right? But then, they basically blew up they set it on fire, and people died on that case. So the British ambassador, right, Daniel Webster, put out some criterias of what is self-defense. And essentially what is self-defense is that, one, it must be necessary and proportionate. So these are the very, very two fundamental criterias of self-defense, right? And you should give some examples of what does this mean. What is necessity? Necessity, of course, really just means the least obtrusive measure to achieve your end. So, for example, someone accidentally violates your airspace. You don't just, commit genocide, right? That's pretty bad. You choose the least obstructive method. Maybe what is necessary in that case would probably be a diplomatic talk, or condemnation, maybe, or report the incident to the ICJ. I'm not quite sure. But the fact of the matter is, it must be necessary and it must be proportionate. So you would also have to explain proportionality, by the way, and proportionality is a little bit harder to explain because there isn't really a surefire way to say that this is proportionate. This is not really depends on your depends on the case, I guess. Depends on the case and your reasoning. Now, we are going to be looking at, if that is the CIL relating to self-defense, we're now going to be looking at the conditions of the use of force. So, conditions of the use of force, i.e. conditions of self-defense. What is it? Can you initiate self-defense unilaterally? No. Sorry, I mean you can do it unilaterally, but there must be certain criteria to be fulfilled before you just use force. So, the first one is there is an attack, right? There is an attack. So you go to the slides and you should read this part specifically. See? When there is an armed attack, the right of self-defense can be invoked. Right. So that is That is the first criteria of what it is. Okay. Now, what else? What else do they need to do, right? So, with regards to the um with regards to self-defense, we go back to the Caroline case to look at it. Another case is that, like, it must be instant, overwhelming, leaving no choice of means, no moment of deliberation. What does that mean? It means that, there is a time to respond, basically. So if someone attacks your country, you can't just wait 50 years and then you attack them back and you claim self-defense. That's not how that works. Self-defense, if I could link it a little bit, it's like Thai law, self-defense, it must happen right there. It must be imminent, right? That's where you activate your self-defense in your inherent right. And now, okay, we move on to the third criteria, which we must, any act of self-defense must be reported to the UNSC. So this is where Article 51 can give us some answers, right? Okay. Measures taken by the members in exercise of this right of self-defense shall be immediately reported to the Security Council and shall not affect the blah, 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 blah. It doesn't really matter. Okay. So what matters is you need to report it to the UNSC. And that is basically the criteria of explaining self-defense. All right. Now what else? So that is only the first sentence, right? The second sentence is a little bit more, let's just say it's very, very hard. So if you remember in class, Ajahn Jha has mentioned that these days, I think she mentioned that while in Britain, she has 40 seconds to find cover if missiles were launched from Russia. So that's a very interesting case. Why? Because it would mean that does this new age warfare where everything happens not in hours or days, but in seconds, right? What does that mean for self-defense, and what does that mean for the use of force in general? So we have to first analyze the second part of this question. Do you agree that would be in the end? With the development of high technological weapons, the futuristic wars will be invoked by preemptive self-defense. So this is where you gotta explain. You gotta explain the development of high technological weapons and futuristic wars. And explain why this would be a problem for traditional concepts of self-defense. So I have already explained it, seconds literally. They don't have time to respond at all, right? You do not wait to be shot. Basically, that's what they're saying, right? And what would that mean? It would mean that, if we're going by the old criteria, which is that there is an armed attack, then the country that initializes its self-defense would have no chance, right? So they would have no chance at all. So that's where you explain the significance. There's no chance. Now, you explain what preemptive self-defense is. So just define the terms very easily. Preemptive just means before, right? Before the incident happens, you initiate self-defense, right? And this is where you should give some examples of that case that of cases where this might be happening in the future. Maybe in the case of South China Sea, Taiwan, or maybe Russia if they wanted to you do that, right? But at the end of the day, you need to explain your understanding to the professor. Of course, don't explain anything irrelevant, as I've learned the hard way. Right. Now, we move on to our final part, which is, do you agree This is an open-ended question. There is no right or wrong. You can agree or you cannot agree. It doesn't really matter in my opinion. I think what matters is the reasoning behind your agreement or disagreement, right? Okay. So let's say that you agree. Right, so you're going to have to give some opinions of why you agree. Maybe in this case, you could cite the fact that they don't have time. Like if someone points a gun at your head, you're not going to wait for them to fire until you fire back. You're going to shoot back, right? You're not going to wait for them to do that. Same notion, If there is considerable evidence for a country to, attack your country, you're not going to just sit there and wait. But the fact of the matter is, you need to attack them back, or else your country is going to be all gone, right? Of course, you're going to have to explain the downsides of your opinion, with the opinion being countries can just start claiming preemptive self-defense if it feels threatened anyway, right? So you're going to have to explain that stance as well. Now, what if you disagree? I've just given you the answer just now. You could basically just talk about the abuse. The countries are going to abuse this like crazy, right? If you can mention preemptive self-defense, you better have very, very clear criteria of what is preemptive and what is not, because you can exercise that and call it a right, which you gotta keep in mind the objective of the UN Charter is to prevent war, not to start it, right? So be aware of that. But anyways, both opinions, I do think that the professor doesn't mind, hopefully. Okay, so that is question 1. Now we're going to be moving on to question 2, which actually is quite lucky this year because Ajanta has mentioned that the first topic is going to be about the use of force, the second topic is going to be about the sources of international law. So this is one of the most fundamental questions actually. Quote, how do we know if an international document is or is not a treaty? Right. So we already learned this before midterm, okay? We learn it. Where do we find the sources of international law? Don't write this down, by the way. I do think it's very irrelevant, but it's ICJ statute, the 38 subsection 1, right? So that's very, very simple. So it is a treaty. Okay. Now, what is a treaty? Okay, now this one you should write down. So where do we find a definition of treaties, if anyone can remember? Yes, it is in the Vienna Conventions on the Law of Treaties, 1969. Okay. Right, or the VCLT, because abbreviations, right? Right, so where do we find that definition specifically? It's in Article 2, subsection 1A, which states that a treaty means an international agreement between states, whether concluded between states in written form, governed by international law, whether embodied in a single instrument or in two or more related instruments, whatever that particular designation. Right, so the question is quite simple. How do we know if an international document is or is not a treaty? Basically, it fits all of these criteria, but you need to also explain what is not a treaty, right? So for example, in the case of the joint communique in the Aegean Sea case, right? That is not a treaty, but I'll explain that down the line. So let's first start with what is a treaty, right? So the treaties, this is in my oath notes, by the way, if you guys want to open that up. It is an international agreement concluded between states in written form, governed by international law, whether embodied in a single instrument, whatever its particular designation. Right, so what does it mean? An international agreement concluded between states. Let's separate that a little bit. Let's separate that, okay? International agreement concluded between states. Cool. So this is really two things. One, international agreement. Right. So two, concluded between states. So what is international agreement? What does that tell us? An agreement internationally. Right, an agreement. An agreement, what does that mean? And when you come to an agreement, what do you need? You need consent, right? You need to declare your intention to be bound by it, i.e. your consent. In fact, if I were to link this in Thai law, right? That's basically what a contract is. It's an agreement. Without the consent of both parties, without the declaration of intention, there is no contract, there is no agreement. So that's the same thing. The same thing is an international agreement, right? Okay, and it's also considered to be a source of law. Again, going back to ICJ statute article 38 subsection 1. Okay, sorry, I need to write that down. Right. Secondly, concluded between states. What are states? What are states? States are basically countries, right? However, you also have to explain that it need not be states. It can also be international organizations. It can also be specific entities in practice, of course. Like the Vatican. And finally, very debatable, but liberation movements. So, yeah. Debatable. Right. So that is the first part of what is a treaty. Second part. In written form. Again, in written form is quite obvious, not oral. Not oral form. Although this is, again, debatable. Secondly, it's based on the consent of the states. The key term here in these two issues is consent, right? So an international agreement concluded between states, you're going to need consent. In written form, consent. Now, why is consent also in written form? Because it's signified through the written form. Signified through maybe signatures and ratifications. Right. So that is again a part of consent, right? Consent is very, very important. Very important, right? Now, we move on to the third part, which is governed by international law. This one is quite simple. This one is basically, layman's terms, right? Governed by international law. So what are the applicable international law? Of course, there's GPL, right? There's the VCLT. VCLT, fun fact, if you guys forgot about this, is the codification, of customary international law. So the VCLT is literally all custom. So, fun fact, even if you're not part of the VCLT, you would ironically still be bound by it. Unless, of course, you're a habitual protester, but that's a completely separate issue, and that is irrelevant in this case. Right, so VCLT, custom, it's already in customs, and then, of course, subject to use cogents. Use cogents, of course, is unwaverable law. You should already learn this in LB100, all right? All right, now the final one. The final one is whether embodied in a single instrument, whatever is particular designation. Okay, that's good. What does this mean? It means it doesn't matter what it's called, right? Whether embodied in a single instrument. Instrument, in this case, means the treaty itself. When we call the paper, right, of which the treaty is from, we just call it the instrument. So whether embodied in a single instrument really just means the treaty doesn't have to be a one package deal. It can be multiple treaties combined to one. Let me give you a very, very quick example. So I think some of you guys know about the Geneva Conventions. You guys learned that in IHL with Ajahn Zhouนะครับ. The Geneva Conventions actually have an additional protocol. Or, if you guys remember the Pravihan case, I don't think the Geneva Convention is a good example, sorry. But you go to the Pravihan case, right? So the Annex 1 map. The key term here is annex. Annex really means add on, right? Add on. When you annex something, you add it to your collection. Is it embodied in a single instrument? No, because there's two instruments now. There's the map, there's the treaty. But it doesn't matter because they're both treaties either way, as the court has told us, right? Whether embodied in a single instrument doesn't matter. Okay. Now, whatever its particular designation. Again, it doesn't matter what it's called. It could be called a treaty. It can be called a convention, protocols. Again, going back to the Geneva Convention, Geneva Convention Additional Protocol 1. It's called a protocol, but it's a treaty. Anyways, it doesn't matter. A covenant, a declaration, convention, the Vienna Convention is itself a treaty, even though it's called a convention, right? Or the law on the sea, right? UNCLOS. Okay, UNCLOS is quite straightforward that it's a treaty, so I'm not going to debate on that. Right. So I'm just going to paste this down. Okay. Now, the real question is, how do we determine what is a treaty? Right. How do we determine that? Of course, there's two ways to do it. Okay. One, de jure. You should already know what this means, but if you don't, it means in law, right? And de facto, in fact. Very easy. So in law, we just look at the documents itself. Sorry, I spelled de facto, not de facto, right? See the words of the document. Is there consent? Or do they want to make a treaty? Right? So you can determine it from that. Or de facto in the practices. Okay. And now this is where you show off. I don't like to use that term anymore, but this is where you show off to the professor that you know what you're talking about. So we now know what is a treaty. It's all of this. What is not a treaty? Right. So this is where you need to apply some cases. Aegean Sea Continental Shelf. That's the 1979 version. Right. So the court held that, again, what the instrument is called is not important. However, the joint communique by the two parties was not considered a treaty because there is no signatures from the PM. It's a diplomatic communication. So the key term here, what do we take away from this, right? We take away the fact that it doesn't matter what it's called, as confirmed by this, whether embodied in a single instrument. What really matters is the agreement. Is there an intention to create a treaty? And in this case, there is none. Therefore, it is not a treaty. However, we move on. Maybe a joint communique is not, but to reiterate that literally anything can be a treaty. You could look at Qatar versus Bahrain. 1994, right? So in that case, again, the court held that the name is not important, but the consent and the intention to be bound, to be legally bound by the treaty is what makes it a treaty, right? So in this case, the Bahraini formula plus the minutes, you see what it's called? It's called a formula and minutes, meeting minutes. When you're in a club and the secretary writes the meeting minutes, that's what it is. They constitute that as a treaty because inside those meeting minutes has the intention to be bound from both parties to the meeting minutes, i.e. making it an international agreement. Right? So, in order to determine what a treaty is, it has to be considered on a case-by-case basis. Okay. Right. And, well, that is basically the answer for question 2, hopefully. So, well, I have no words, but I really wish everyone the best of luck in, public international law. It has been tough, but I'm sure we'll all pass together. All right. So have a good night, everyone. I'll see you guys.